Michael Franz here for the plaintiff appellant, Elevation Outdoor Advertising, LLC. And I have with me today Mr. Martin Daniel, who is the CEO and General Counsel of Elevation Outdoor. I would like to reserve 4 minutes for rebuttal, please.
Four,
yes,
that'll
Your
be fine.
This is an action for a declaratory judgment to contest the validity of 3 different ordinances that were passed by the City of Pigeon Forge in 2021. And these ordinances impacted the plaintiff, Elevation Outdoors' ability to receive sign permits that it had applied for at that time. So I'm going to start out for context going back to before Elevation submitted its applications in this case. Prior to February of 2021, there were 2 bodies of law in the City of Pigeon Forge that regulated signs, and those were first, Chapter 4 of the City Municipal Code entitled Outdoor Advertising Signs, and we define that in our complaint as the Billboard Code. And secondly, there were sign regulations that were contained in the city zoning ordinance, and those are defined in the complaint as the former sign regulations. And both of those were enforced prior to February of 2021. The first date that's important in this case is February 5th of 2021. On that day, the same trial court in this case, Sevier County Chancery Court, held a hearing on a motion for summary judgment that was filed in a prior case, Howard W. Reagan versus City of Pigeon Forge. In that prior Reagan case, the plaintiff was a permit applicant who had applied for a billboard type sign permit, and the city had denied the application based on the billboard code and a distinction in the billboard code between on-premise and off-premise signs. Essentially, the billboard code banned all off-premise signs. And the plaintiff had filed for a declaratory judgment in that case, arguing that he was entitled to his billboard type sign permit based on the invalidity of the billboard code, because the billboard code had not been presented to the Planning Commission for approval as required by TCA 137203. That statute is a state law that requires any zoning ordinance to meet several different procedural requirements. It has to be presented at a public hearing. Notice has to be published of that public hearing before the hearing occurs, and the ordinance also has to be presented to the Planning Commission for approval. 137203 requires that all those steps have to be carried out before the zoning ordinance can be valid. So in this Reagan case, the city admitted that it hadn't presented the billboard code to the Planning Commission for approval, but instead argued that the billboard code was a police power ordinance and that it didn't have to present the ordinance to the Planning Commission. But the Sevier County Chancery Court rejected that argument and granted the declaratory judgment, held that the billboard code was unenforceable and invalid because it hadn't complied with state law. The trial court also found that the billboard code was tantamount to zoning, such that those procedural requirements in 137203 applied to it. And the trial court allowed Mr. Reagan, in that case, to construct his billboard type sign that he proposed. So after that point, the city realized after that hearing on February 5th, 2021, that it had a problem because the sign regulations that were applicable in the city were invalid, and there were no sign regulations that applied in the city. So on February 22nd, 2021, that was 1 day before the trial court entered its written order confirming its decision from the February 5th hearing, the city tried to pass a moratorium ordinance that would ban all sign permit applications for a period of 60 days. And the moratorium stated on its face that its purpose was to prohibit all sign applications in order to give the city time to put together a new sign ordinance that complied with the law. And there were also some First Amendment concerns, so they were trying to correct those at the same time. And so they were trying to use the moratorium to block anyone from getting any sign permits approved until they could pass that new law. But the city made the same mistake with the moratorium that it had made with the billboard code before. It didn't present the moratorium to the Planning Commission for approval as required by 137203. The moratorium was also a zoning ordinance because it substantially affected the land rights of landowners, and it was tantamount to zoning. So the moratorium was void for the same reasons that the billboard code had already been struck down by the Sevier County Chancery Court. So at this time, the February-March period of 2021, there were no valid sign regulations in effect in the city of Pigeon Forge. The billboard code had already been declared invalid. The former sign regulations and the moratorium both suffered from the same defects as the billboard code. So there were no sign ordinances in effect as of February 23rd, 2021. So now we get to Elevation. Elevation submits 6 applications for sign permits, all billboard type signs, on March 12 and March 15 of 2021. Rather than processing those applications, the city just sits on them. And there's an issue in this case about whether the city was relying on the moratorium. Based on the facts that are pled in our complaint, I think it's pretty clear that the city was not processing those applications because it had attempted to enact a moratorium that said we're not going to issue any sign permits for 60 days. This was within that 60-day period. And this case comes to this court on basically at the judgment on the pleading stage. So all the facts that have been pled in our complaint are entitled to be taken as true. So the moratorium certainly appears to have been a reason why the city took no action on Elevation's applications. And but either way, it's undisputed that the city held on to those applications, didn't do anything with them until it had it repealed the former sign regulations and passed what we've defined as the new sign regulations. That occurred on April 12, 2021. And then on April 27, 2021, the city finally processed Elevation's applications and denied them based on the new sign regulations that weren't in effect at the time Elevation submitted its applications. That violates state law because the rule in Tennessee is that permit applications have to be considered based on the law that's in effect at the time they were submitted. It's undisputed that the new sign regulations weren't in effect then. So the city held on to those applications, didn't do anything with them, and then denied them based on an ordinance that wasn't in place at that time. So Elevation filed its complaint for declaratory judgment, and that's what the issue is in this appeal. The city's argued, and the trial court agreed and dismissed Elevation's complaint based on a finding that this was in substance a certiorari petition and not an action for declaratory judgment. The trial court got that wrong because the whole thrust of Elevation's complaint is an action to declare invalid those laws, the billboard code, which had already been struck down, the former sign regulations, and the moratorium. So Elevation's argument is that there were no sign regulations in effect at the time its permit applications were submitted, and so therefore the city had no choice, based on the invalidity of those laws, those legislative enactments. There was no choice but to grant the applications. So the trial court was incorrect in finding that this was an attempt to review an administrative or quasi-judicial decision by the city, because there's nothing in Elevation's permit applications that is relevant to the question that's presented in Elevation's complaint. This turns on the validity of the ordinances, not on the application of existing law. I think both sides here agree about the general test between a legislative enactment is passing law versus an administrative decision is applying that law, that existing law, to the facts of the permit application. That it's just not relevant here because the facts of Elevation's application are not part of what we're contesting. The question is what laws were in effect at the time the permit applications were submitted. So there is no administrative or quasi-judicial decision that we're attempting to contest. I think maybe the best way to summarize it is that Elevation is challenging whether the law that was applied was an existing law, not how the existing law was applied to the facts of its applications. So the case is about the legal validity of the billboard code, the former sign regulations, the moratorium, and then the question of the new sign regulations being applied when they weren't in effect when the applications were submitted. That was a clear violation of Tennessee law. And we've cited some other cases in our brief about how a declaratory judgment action is appropriate when there are essentially legal arguments that are being presented. There are no factual determinations about what either the Planning Commission or the codes enforcement officials considered when they applied elevations applications. I think another point is that if the new sign regulations were applied to properly, and they weren't, but if they had been applied to elevations applications, I think we agree that they would have been properly denied. So the question is not how the codes enforcement looked at the applications. The question is, what law should they have considered? So I think that's clearly appropriate for a declaratory judgment action. It's not a certiorari petition. And so the 60-day statute of limitations, which was the reason the trial court threw out elevations complaint, didn't apply here. There is no statute of limitations applicable to a declaratory judgment action, but the 60-day limitation in state law wouldn't apply. The verification requirement, which is another requirement for a petition for writ of certiorari, that also wouldn't apply. And so there's no basis to dismiss elevations complaint. So this should be reversed and sent back to the trial court to allow the case to proceed at this stage. Thank you.
Thank you. You have your time for rebuttal. Hear from the appellee.
Good morning, Your Honors. May it please the court. Brian Bibb on behalf of the City of Pigeon Forge. I want to just address, my friend on the other side did a very good job of summarizing the very tight time period when these actions took place, but I do want to address a couple specific points on that. I think it's worth emphasizing that the billboard code, which for our purposes today, all that ordinance did was prohibit off-premises advertising, which there was a Supreme Court case that came out in 2020, 2019, Gilbert versus Arizona, that changed the standard of First Amendment law with respect to on and off-premises advertising. That was one of the grounds for Chancellor Fogarty's decision. No dispute that the billboard code was invalid and remains invalid. It's already been declared invalid. No dispute about that. The city did not apply that. It is not true to say that that impacted anything on what we've called the former sign regulations, which are the nuts and bolts of signs. Where do you put them? How bright can they be? How tall can they be? How large can they be? In what district? Those types of things. Traditional zoning requirements for signs. Those were not impacted by Chancellor Fogarty's decision. The plaintiff has, in its complaint, it made a passing allegation that the former sign regulations were invalid. But the former sign regulations are a comprehensive zoning ordinance that contain multiple individual enactments and ordinances. The plaintiff has not pled, even to a notice pleading standard, adequate information to support a finding that those are invalid, because the plaintiff doesn't say this ordinance enacted on this date was invalid or this subsection of the former sign regulations were invalid. The complaint simply does not have even a notice pleading standard sufficient to assert an allegation that the former sign regulations were invalid. And if they weren't, there's no dispute that the signs were simply too big, that they were properly denied because they were too tall and too large. No dispute among the parties that these signs did not meet the nuts and bolts requirements of either the old or the new sign regulations. So this ultimately comes down to the question of whether or not the decision that was made by the City of Pigeon Forge Planning Commission and planning staff on April 27th, 2021 was right or wrong. Plaintiff has taken the position that, well, we're not really challenging the correctness of the decision, we're challenging the validity of the underlying ordinances. Well, that gets you only so far with respect to the moratorium and the former sign regulations. The new sign regulations, plaintiff does not challenge their validity. Plaintiff simply says that the planning staff and the planning commission got it wrong when they applied those provisions. So plaintiff could have timely challenged that decision by seeking certiorari review. There's no dispute here that if certiorari is the correct remedy, that the chancellor got it right below in dismissing the action. It was not filed within 60 days of the decisions that were made in 2021, and it was not properly verified. So there's no question that if certiorari is the right remedy, dismissal was proper. Plaintiff is attempting to capitalize on a moment in time at which they allege there were no applicable sign regulations. Of course, we disagree with that. So it is also worth noting, and this is clear from the record that plaintiff went to federal court first. That's why we're so delayed in getting where we're at today. Plaintiff filed their claim as a First Amendment challenge in federal court in March of 2022. It was dismissed on February 16th of 2023. The state court action was refiled on November 6th, 2023. So the plaintiff's underlying action, understand they can't, when they file that underlying action, they are aware that they've missed the boat on certiorari. They're not going to be able to take advantage of that remedy. So they have to recast their claim for relief for something that is not barred by the applicable statute of limitations. And they've settled on the declaratory judgment action. Certiorari, this is well-rehearsed law, is the correct remedy to challenge an administrative decision. Plaintiffs ultimately and foundationally allege that the city got it wrong when it denied their sign permit applications. There was some discussion, and maybe the court did this on purpose to put us people dealing with administrative cases together, but there was some discussion in the previous case about there's certain things that are reviewable by DEC and certain things that are reviewable by certiorari, and that it may be prudent to seek both of those remedies, even in separate actions. There's good law that says you can't combine them, but there's nothing that prevents you from seeking both of them. So this isn't a situation where plaintiff was deprived or unable to timely seek certiorari. They simply failed to do it. And now, knowing that they failed to do it, they've tried to spin their claims into something that excuses them from that untimeliness. So plaintiff could have, theoretically, brought a challenge to these ordinances. Another important distinction here is that each of the ordinances they challenge in terms of their validity, being the former sign regulations and the moratorium, were repealed in April of 2021. So there's no live case or controversy to even address the validity of those ordinances. There's no grounds for prospective relief. That's what a declaratory judgment does. There must remain a justiciable case or controversy seeking prospective relief. The plaintiffs are asking the court to issue a retrospective finding that those statutes were in 2021 invalidly enacted. But then, but what's the next thing that the plaintiff wants you to do? The plaintiff says, all right, once you've done that, then make the second finding that because those were invalid, the administrative body got it wrong. Its decision was incorrect. You should do what is a traditional certiorari remedy, which is vacate, remand, or remand with instructions. Plaintiff says send it back to the city and order the sign permits to be issued because the sign permits were denied invalidly, because the local official erred in making that judicial or administrative determination. We've cited in our brief a series of cases that this court has on regular occasions held that if you are challenging the denial of a sign permit application, that certiorari is the correct remedy to challenge that administrative or quasi-judicial denial. So plaintiff, attempting to avoid the consequences of not pursuing certiorari relief, plaintiff says, all right, well, instead let's pursue declaratory judgment and mandamus relief on the theory that those are timely. So let's take those claims with respect to each of these bodies of law they challenge. So the former sign regulations, I've already addressed that. The allegations in the complaint don't even meet a Rule 8 standard. This is a complex statute which is in the record. Plaintiff attached all of these to the complaint, so perfectly legitimate for the court to consider those at the motion to dismiss or judgment on the pleading stage. The court can review that and see that the ordinance has dozens of statutory credits, essentially like when you read a statute that shows when it's been amended. What provision is the plaintiff challenging? Is it all invalid? Is one portion of it invalid? And which particular enactment, which particular amendment is invalid? The complaint doesn't give us any of that. That's simply insufficient under Rule 8. The billboard code isn't something the court needs to deal with. The chancellor in the Reagan case declared it invalid. We didn't apply it. We don't allege that it's valid. The moratorium. The plaintiff alleges that that was not passed pursuant to 13.7208, but the moratorium was not applied based upon the documents that we have in the record. The court can see what the planning staff did. The planning staff said, elevation, I'm sorry, your signs are too big. You can't build them. Here's the subsection of the sign regulations that tell you what your square footage and height is. It doesn't meet that standard. The new sign regulations, again, the plaintiff doesn't challenge the legitimacy or validity of those regulations. The plaintiff simply says that you got it wrong in applying them. The plaintiff says that they weren't legally pending. I don't know that I need to go into this in any depth. The court may be aware that there was a legislative amendment to the pending ordinance doctrine in the legislative session in 2023 that essentially legislatively abrogated the pending ordinance doctrine. I don't think we have to get there. We've not briefed this, but I do want to just mention, because my friend mentioned it, that that would not have retrospective effect. It would apply to subsequent applicants who go before it, but it wouldn't reach backward in time and change the fates of a currently pending litigant in a currently adjudicated matter. So, ultimately, in order for the court to grant the relief the plaintiff is asking for, it must do more than simply pass upon the validity or invalidity of ordinances. It must conclude that the administrative body erred, that the administrative body's reliance on the new sign regulations was arbitrary, capricious, applying the well-tried and true standards for certiorari review. So even if we take plaintiffs at their word that, yeah, perhaps they may have the ability to seek a declaratory judgment on these portions of law, the court still must ask and look to the validity of the decision in order to make a final judgment that is favorable to the plaintiff, in order to give them redress. So let me, and I mentioned this briefly, but let's conclude for the moment. Let's go down this road and let's say, all right, let's just presume for the sake of argument that a declaratory judgment is an appropriate remedy. It still would not result in redress because, as I said earlier, the challenged ordinances are no longer in effect and there is no ground for prospective relief. Plaintiff also raises mandamus. And mandamus, as the court is aware, is a limited remedy that applies only in certain circumstances where there is no other just, appropriate, or speedy remedy. My example for mandamus, and it's an old one, is Marbury versus Madison, which doesn't get cited very often anymore, does it? But essentially, if there's nothing to do but to issue the commission in that case, where the Secretary of State could do nothing other than issue the commission, where there's no discretion to be made, no administrative decision to be made. Plaintiff relies heavily on the Supreme Court's decision in Cherokee Country Club, which I want to address briefly. Plaintiff essentially says, well, hey, in Cherokee Country Club, which as the court may remember, Cherokee Country Club purchased an older home near its location and wanted to demolish that home. Mayor Ash at that point intervened to attempt to try and stop Cherokee from demolishing that home. So plaintiff relies on Cherokee, and plaintiff essentially says, well, in Cherokee, those were the remedies that the plaintiff pursued in Cherokee Country Club. What's different about Cherokee Country Club? Number one, nothing in Cherokee stands for the proposition as to the propriety of the remedy. Certainly those were the remedies selected, but nothing in either this court's decision or the Supreme Court's decision in Cherokee discusses whether those were the correct remedies. And in Cherokee, even though they selected a declaratory judgment action, it was still filed within 60 days of the challenged action, and the Court of Appeals decision indicates the complaint was a verified complaint. So it really was immaterial. And the law is quite clear from this court that even if the selected remedy is incorrect, the court can interchange them so long as the procedural requirements of the statute were met. So in Cherokee, it didn't really make any difference how they pled it because it would have been timely and appropriate under the certiorari statute regardless. Second, under Cherokee, they were challenging an active in-force ordinance, an ordinance that still stood in the way of Cherokee's desire to demolish this property. Prospective relief was appropriate. There were grounds for a future redressable wrong that could be remedied by a favorable declaratory judgment action. Third, it challenged a non-discretionary decision. All that was at issue in Cherokee was the issuance of a demolition permit. There was no dispute that Cherokee was entitled to that demolition permit. The only dispute is whether they could get it within the historic zoning overlay and whether the historic zoning overlay had been properly enacted under the terms of the zoning ordinances. Fourth, in Cherokee, in the end of the Supreme Court's decision, they indicate that the court did not err in selecting mandamus as the appropriate remedy because there was no other just and speedy remedy available for relief. In other words, mandamus is an appropriate remedy where there is no other choice. The plaintiff had another choice here. It could have timely and properly pursued certiorari. It elected not to pursue certiorari. That doesn't mean that the fact that they missed the statute of limitations on certiorari gives them the right to pursue the extraordinary writ of mandamus, because in this instance there was an appropriate remedy which they failed to pursue. Further, the plaintiff could have appealed to the Board of Zoning Appeals from the Planning Commission's denial below. And it could have sought a variance, which a variance is an entirely different standard than the strict application of the sign ordinance. If it wanted to build its large, tall signs, it could have gone to the BZA and said, hey, we'd like to build these big signs, please give us permission to do so. The BZA could have applied the variance standard and could have afforded them relief from the strict requirements of the zoning ordinance if the standards were met. But they didn't pursue that, and they concede they didn't pursue that. So mandamus is inappropriate because they could have sought certiorari and they could have gone to the BZA, and they did neither. In the little time that I have left, let me just summarize, and then if the court has any questions, I'm happy to address them. This is ultimately a review of an administrative or quasi-judicial decision. As I've explained, the plaintiff does not state a redressable claim because the underlying ordinances have been repealed, and because the federal court concluded this, and we've put this in our brief, under any of these applicable ordinances, pick one, whatever one it is, the signs weren't permissible because they were too big and they were too tall. No doubt about it. And that was the federal court's ultimate conclusion. The federal court says, we don't have to reach the First Amendment issues because your signs were not permissible. Your signs were too large and too tall. It's the city's position that the trial court correctly determined that this matter was reviewable solely and exclusively under the common law writ of certiorari. The trial court correctly concluded that the complaint did not meet the procedural and jurisdictional standards of that statute, and we would ask the court affirm the trial court's decision below. Thank you.
Thank you. Here's the appellate rebuttal.
So I'll start with the issue of justiciable controversy. These are new arguments that were raised for the first time on appeal. The idea that even if Elevation's complaint was properly a complaint for declaratory judgment, there was still no justiciable controversy. That was never presented before the trial court. It was never considered by the trial court, and it wasn't a basis for the trial court dismissing Elevation's complaint. The only basis for the trial court's dismissal of Elevation's complaint was the distinction between certiorari and declaratory judgment review. Another point about the pending ordinance doctrine, once you get into these issues on justiciable controversy, they all involve facts that go beyond the scope of the pleadings. And the review here at the judgment on the pleading stage is just limited to the pleadings. So Elevation did properly plead in its complaint that the pending ordinance doctrine didn't apply here because this ordinance had not been presented for a public hearing at the time that Elevation submitted its application. So even though the new sign regulations hadn't been passed yet, the city is saying because they had been presented to the city commission for first reading, they should have still applied. But that involves factual issues that go well beyond the scope of the pleadings. And Elevation's done enough in its complaint to plead that the pending ordinance doctrine didn't apply. There is the statute also. I think that statute may have retrospective application because the General Assembly said in that statute that the doctrine of the pending ordinance doctrine is against the public policy of Tennessee. It is absolutely void and contrary to public policy. The issue of the federal court action that was filed before this case, that has no application at all to the issues here. Even the trial court acknowledged that there was no collateral estoppel finding or any sort of binding application of what the federal district court did in its summary judgment decision because that involved only the First Amendment federal claims, and the federal court expressly stated in the opinion that it was declining to exercise supplemental jurisdiction over any of the state law claims. So the federal district judge said that his opinion had no bearing on those issues. They were dismissed by a decline to exercise supplemental jurisdiction. So the federal court ruling has no bearing. This issue about the former sign regulations, the city wants to play both sides of that. And they say in their answer that the former sign regulations weren't applied to Elevation's applications and therefore are irrelevant to this case. But then they say, well, if the former sign regulations had been applied, then there's no justiciable controversy. But Elevation did do enough in the complaint to plead that those former sign regulations were also invalid for the same reason as the billboard code and the same reason as the moratorium, and that is that they violated TCA 137203. This issue about how the former sign regulations are a complex body of zoning law that was amended over time, that's true. And there's another statute in the same body of law as 137203. I think it is 137204 that says anytime there's an amendment to a zoning ordinance, that amendment has to comply in all respects with TCA 137203. In other words, it has to be presented at a public hearing, there has to be published notice of that hearing, and then it has to be presented to the Planning Commission. So every one of those steps in the statutory credits of the ordinance, the city had to comply with each of those steps, and that is an issue that takes into account facts that go well beyond the pleadings. And so the case is going to have to proceed through discovery to get to that point. And that just hasn't happened here. So at the judgment on the pleading stage, that should not be considered. Thank you.
Yes, thank you.